Disclosure of documents in the context of litigation is an area where the approach taken in Scotland does differ greatly from that in England and Wales. For instance, there is no general obligation to disclose in Scotland. Once a dispute has arisen, documents may be able to be recovered by agreement, but if the documents are not disclosed voluntarily, an application must be made to the court to compel the party holding the documents to disclose them. The person in possession of a document in Scotland is called the haver, and the haver can be any third party, not just the parties involved in the case. So it might be the HSE or the Crown, or more often than not it can be a solicitor. The method for asking a court to order disclosure of documents depends on if the action is live or if it is only in contemplation. Looking firstly at disclosure of documents prior to a court action. Parties contemplating litigation may want to see documents relevant to their case as part of the pre-action preparation, and the only way to achieve disclosure of documents before the action is commenced, and of course in the absence of voluntary disclosure, is by way of obtaining what is called a Section 1 order, and that is an order under Section 1 of the Administration of Justice Scotland Act 1972. A Section 1 order can be brought ex parte, that is, without giving notice to the other party. Those are often referred to as dawn raids, as when the Section 1 order is granted, the person considering bringing the action will often raid the premises of the persons holding the documents first thing in the morning to maintain an element of surprise and to protect against the documentation being destroyed. The test for an ex parte Section 1 order is very stringent, and there must be a real risk that evidence relevant to court proceedings is likely to be concealed or destroyed.
Our recent experience of Section 1 orders has been where we've been concerned that evidence held electronically will be deleted. The party making the application under Section 1 must have what we call a PRIMA FACIE case. That is, an arguable case on the face of it, that the documents exist and that they may be relevant to later court proceedings that are likely to be brought. So-called fishing expeditions, where applications are made on the off chance that there may be relevant documents held, which could give rise to an unspecified claim, are not allowed. If a Section 1 order is granted, a commissioner is appointed, and that's usually a senior member of the Scottish Bar. And power is often given to the commissioner to remove documents or property and to employ such persons as he or she considers appropriate that could assist in the inspection and removal of documents. In our recent experience, that may involve the employment of an IT expert in order to properly search for electronic data that may be concealed. The Commissioner will be given power to enter into premises where it is thought the documents may be located and to search for and to open lock-fast premises. The Commissioner will be accompanied by a shorthand writer who acts as his clerk. Sometimes the court permits the petitioner's solicitor to accompany the Commissioner in order to identify property, but the petitioner's solicitor should not really assist the Commissioner, as that can lead to all sorts of conflict issues later on.
Looking at recovery of documents during a court action, as I mentioned, in Scotland, there is no general duty to disclose, and the court rules set out how documents can be recovered from third parties during a court action. A court will only order documents to be produced if the party seeking disclosure can demonstrate the documents are relevant to their claim and support its pleaded case. As with Section 1s, the court will not authorise fishing expeditions. There has to be written pleading to support the production of the relevant documents, and that is to avoid fishing expeditions because, of course, you shouldn't plead any factual statement unless you know you can prove it. The application for recovery of documents during a court action is framed as a specification of documents, which requires the approval of the court. A specification expressed in too wide terms and without reference to the facts of the case will not be granted. It may also be refused if the terms are too vague.
There is a fine line between the need for evidence to elaborate an existing and known case and a fishing diligence, where one might be hoping to find something that would support a case that without it cannot be made. Accordingly, a specification of documents produced by one side will in all probability be argued over by the other side. When the specification of documents has been approved by the court, though, the solicitor seeking recovery has a choice as to the procedure to be adopted. He may use the optional procedure, which entails the serving of the order on a person believed to hold the documents who's requested to produce them voluntarily. When the specification of documents is approved, it's not necessarily the case that it will refer to a particular document held by a particular person. It may call for the production of all documents showing or tending to show X, Y, Z. The specification of documents and the court order will be served not necessarily on the other party to the action, but on any party that might be thought to be a haver. A haver may claim confidentiality, in which case the documents they produce must be placed in a confidential envelope and returned to the court rather than to the other party. And the court's authority will be required before the envelope is opened up. Alternatively, the party seeking recovery can go straight to what is called an open commission. And that is a diet at which havers will be cited to attend, and it's presided over by the commissioner. A haver will then be asked if they have any of the documents referred to in the specification of documents, and if not, whether they ever did have them, and what has happened to them since. A haver is entitled to be represented at the commission, and he's also entitled to a fee for the trouble in searching out the documents called for. Although, in the case of solicitors holding documents, that fee will not be at the solicitor's rate, but will be an appropriate fee for the administration that's been involved in searching out.
Difficulties arise where documents sought to be recovered are not located in Scotland. There are no means of enforcing an order for production of documents out with Scotland, and letters of request would require to be addressed to the appropriate foreign court. If, however, the documents held out with Scotland are in the hands of one of the parties to the action, the Scottish court will expect them to be produced.